Scott Simpson.
Thank you, Mr Speaker. As Chairman of the Local Government and Environment Select Committee that has considered and guided this bill through Select Committee process, it's a pleasure and a privilege to speak in this third reading debate, and particularly so following Phil Twyford, who has come to this third reading debate ill-prepared, ill-informed, and trying to fluff and fill 10 minutes on a range of subjects to do with all sorts of things other than the bill. Now, sir, this is a small bill, but it's an important bill, and to discount with such arrogance, really, the impact that this bill has on the people affected is to discount their situation in a way that I find appalling and shameful, and I would have expected better from that member. This, sir, is a bill that will amend the Principal Act in a way that gives certainty resulting from a court case that created some uncertainty, and will also help those people who have already spent too much time and too much energy on long and expensive litigation to try and get their leaky homes situation fixed. This is a bill that provides an alternative to a litigation pathway, and I think that's a good thing. I think there have been far too many lawyers involved in expensive litigation in many leaky home matters, and so this is a government that has decided that enough is enough, and it was this government that decided to take action on the whole leaky homes issue in a way that the previous government sought not to do. And given that a major commitment to a financial assistance package was made by this government during a time of incredible tight economic hardship, is an indication of this government's commitment to supporting those people who are confronting leaky home issues around the countryside. So this bill, admittedly, as Mr Twyford said, may only impact on a relatively small number of homeowners, but it's important to them, and it's important that this House duly considers their situation because we'd like to take a pragmatic and a sensible approach to solving those people's issues and to providing them with some certainty. So this bill amends the Principal Act to remove doubt and to sort out the validity of two criteria that determine the eligibility for the financial assistance package, and I, sir, think that's a very good thing. This bill doesn't actually change anything about the financial assistance package itself as set out in the principal legislation. It simply removes doubt and provides claimants access for those who want to take recourse to the financial assistance package and use that methodology to advance a resolution of their leaky home situations. Sir, Clause 2 of the bill relates to the commencement, and it's been amended so that only the amendments made by Clause 7 are brought into force on the 23rd of February 2015, and that's the date on which the bill was introduced to the House. And that's important, sir, because the rest of the bill will now come into force on the day after it receives the royal assent. There was a further amendment made during Select Committee stages, and that involved Clause 7, and that amended it to remove those provisions in the clause relating to the insertion of new subpart 9 of Part 2 into the Principal Act, and those amendments are now moved to a new Clause 8. And this was necessary, sir, to avoid new subpart 9 coming into force on the date which the bill was introduced. Now, this may sound all a bit technical and a bit pointy-headed, but it's actually quite important because the courts are inclined to interpret the legislation that gets passed in this House in sometimes a narrow way, and indeed it was that matter in the case of Osborne and the Auckland City Council that led to a significant issue in the Supreme Court, where they interpreted the word built differently to the way that that word and that term had been interpreted previously by High Court and Court of Appeal decisions. Now, the meaning removed from the point of final council inspection to the point at which a code of compliance certificate was to be issued. And so that's why in this bill we're moving to clarify that definition, and the new meaning of built can be applied not only to future decisions on eligibility but also to make sure that the position for these people is found to be based on a past interpretation in other courts. This bill clarifies the position for past claimants and is an indication, sir, further that we are a pragmatic, sensible and good government in terms of tidying up these matters. Sir, this is a good piece of legislation. It is a small piece of legislation, but it's important, and this is a government that takes these matters seriously. I commend it to the House, and I want to thank committee members for their work in guiding it through to this third reading stage. Thank you, sir.